Since India implemented the significant beneficial owners rules in 2018, aligning with the FATF guidelines, identifying and reporting SBOs has become a crucial aspect of corporate transparency. Recently, the Registrar of Companies has increased scrutiny around compliance of these provisions. It is therefore important for companies to understand the challenges around identifying their SBOs and reporting them accurately. Despite the FATF guidelines, the definitions of SBO vary across countries. Even in the Indian legislative framework, the definitions for SBO vary under the banking regulations vis-a-vis the SEBI regulations and the Companies Act. It is therefore important that companies do not solely rely on these definitions while reporting their SBOs and apply the SBO definitions under the Indian Companies Act independently and accurately report their SBOs. One area of concern is with respect to the test of significant influence and control. The subjective provisions particularly are not one size fits all. In fact, they are designed to be applied on a case-to-case basis. There have been no FAQs or guidelines or clarifications that have been issued that help in interpreting these provisions. The multiple market interpretations have therefore led to greater complexities. Having said that, some of the ROC orders which have been issued in the recent past provide a glimpse of the extent to which these interpretations would apply. For instance, the significant influence test is not just limited to the senior leadership of the Indian reporting company, but most of these orders indicate that they would perhaps extend all the way right up to the top of the global organization, leading up to the global executive. Another evolving challenge is with respect to data privacy concerns on personal information which is required to be disclosed. For instance, there's a lot of personal information on the SBO which has to be disclosed under Form Ben 1, which becomes public through the reporting in Form Ben 2. While we are optimistic that the regulators should sooner than later address this issue, that said, this does not present an option for non-disclosure, and a non-compliance would expose companies and the SBO to penalties. To mitigate these challenges, companies should conduct thorough evaluations of not just their ownership structure, but also their managerial structure. Even companies that have reported their SBOs should do frequent reviews of these positions, not just annually, but also through corporate actions. Taking some of these measures will only help them and mitigate any risks as this law evolves.